One, it's a record vote for final passage. The clerk will please ring the bell. There being 147 ayes and 0 nays, the bill is finally passed. Chair recognizes Mr. Turner of Tarrant for a motion.
Mr. Speaker, I move to suspend House Rule 8, Section 5D for Senate Bill 37 to designate the following members as co-sponsors: Representative Rainey and Representative Thompson of Harris.
Members, you've heard the motion. Is there any objection? Chair hears none, so ordered. Chair lays out on third reading Senate Bill 37. The clerk will please read the bill.
SB 37 by Zaffarini, relating to the abolition of student loan default or breach of a student loan repayment or scholarship contract as a ground for non-renewal or other disciplinary action in relation to a professional or occupational license.
Chair recognizes Mr. Kraus to explain the bill.
Thank you, Mr. Speaker. Members, again, this is the bill that would ensure that just because you default on your student loans does not mean you can lose your occupational license. I move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will please ring the bell. There being 146 ayes and 0 nays, the bill is finally passed. Chair lays out on third reading and final passage Senate Bill 1474. The clerk will please read the bill.
SB 1474 by Lucio, relating to private activity bonds allocated for affordable housing.
Chair recognizes Mr. Murphy to explain the bill.
Thank you, Mr. Speaker. Members, this updates this very important program for the state of Texas, and I move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will please ring the bell. There being 136 ayes and 0 nays, the bill is finally passed. Chair lays out on third reading Senate Bill 568. The clerk will please read the bill.
SB 568 by Huffman, relating to the regulation of child care facilities and family homes, providing administrative penalties.
Chair recognizes Dr. Bonin to explain the bill.
Thank you, Mr. Speaker. Senate Bill 568 strengthens the regulations relating to child care facilities to protect children and keep them safe. Move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will ring the bell. There being 135 ayes and 12 nays, the bill is finally passed. Chair lays out on third reading Senate Bill 633. The clerk will please read the bill.
SB 633 by Colcourse, relating to an initiative to increase the capacity of local mental health authorities to provide access to mental health services in certain counties.
Chair recognizes Mr. Lambert to explain the bill.
Thank you, Mr. Speaker. Members, Senate Bill 633 ensures that limited mental health resources are used effectively and efficiently in rural areas of the state. I move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will please ring the bell. There being 141 ayes and 6 nays, the bill is finally passed. Chair recognizes Mr. Guerin for a motion.
Thank you, Mr. Speaker and members. I move to suspend the 5-day posting rule to allow the Committee on House Administration and a public hearing today at 1 p.m. in room E1010 to consider interim budgets.
Members, you've heard the motion. Is there any objection? The chair hears none, so ordered. Mr. Guerin for a motion.
Thank you, Mr. Speaker. Mr. Speaker, I move the House grant permission to the Committee on House Administration to meet while the House is in session today at 1 p.m. in room E1010 to consider interim budgets.
Members, you've heard the motion. Is there any objection? The chair hears none, so ordered. The clerk will please read the announcement.
The Committee on House Administration will meet today at 1 p.m. in room E1010 in a public hearing to consider interim budgets.
Chair lays out on third reading and final passage Senate Bill 711. The clerk will please read the bill.
SB 711 by Hinojosa, relating to allowing safety recall information to be included in a vehicle inspection report.
Chair recognizes Mr. Leach to explain the bill.
Thank you, Mr. Speaker. Members, this bill is about safer cars and safer Texas roads. Move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will please ring the bell. So Mr. Bell voting aye. There being 135 ayes and 12 noes, the bill is finally passed. Chair lays out on third reading and final passage Senate Bill 1621. The clerk will please read the bill.
SB 1621 by Colcourse, relating to creating a license for certain rural medical facilities, requiring a license, authorizing fees.
Chair recognizes Mr. Price to explain the bill.
Thank you, Mr. Speaker. Members, this bill directs HHSC to issue a limited services rural hospital license if Congress approves such a designation by CMS, and I believe there is one third reading amendment.
Following amendment, the clerk will please read the amendment.
Amendment by Darby.
Chair recognizes Mr. Darby to explain his amendment.
Thank you, Mr. Speaker. Members, this is House Bill 2318 that's currently hung up in Senate. And all this bill does is simply allow the Reagan Hospital District to use private donated funds to construct a new building and lease that new facility to the county for fire and EMS. And I think it's acceptable to the author.
Mr. Darby offers up an amendment. The amendment's acceptable to the author. Is there any objection? Chair hears none. The amendment is adopted. Is there anyone else here wishing to speak on, for, or against Senate Bill 1621? Chair hears no one. It's a record vote for final passage. Clerk will ring the bell. There being 140 ayes and 6 nays, the bill is finally passed. Chair lays out on third reading and final passage Senate Bill 1319. The clerk will please read the bill.
SB 1319 by Birdwell, relating to an annual report submitted to the comptroller by a county that imposes certain hotel occupancy taxes.
Chair recognizes Mr. Murphy to explain the bill.
Thank you, Mr. Speaker. Members, this bill extends the responsibility to report on hot taxes to include our counties. And this transparency measure, I would move for passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will please ring the bell. There being 146 ayes and 0 nays, the bill is finally passed. Chair lays out on third reading and final passage Senate Bill 1414. The clerk will please read the bill.
SB 1414 by Hancock, relating to fees regarding a residential tenant's failure to timely pay rent.
Chair recognizes Mr. Metcalf to explain the bill.
Thank you, Mr. Speaker. Members, Senate Bill 1414 clarifies the law regarding late fees. We passed yesterday. Move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will please ring the bell. There being 94 ayes and 52 nays, the bill is finally passed. Chair lays out on third reading and final passage Senate Bill 1525. The clerk will please read the bill.
SB 1525 by Watson, relating to the application of the sales and use tax to certain property and services.
Chair recognizes Mr. Sanford to explain the bill.
Thank you, Mr. Speaker. Members, this is the Comptroller Sales Tax Clarification Bill. Move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote. For final passage, the clerk will please ring the bell. There being 146 ayes and 0 nays, the bill is finally passed. Chair lays out on third reading and final passage Senate Bill 1861. The clerk will please read the bill.
SB 1861 by Menendez, relating to certain public facilities financed, owned, and operated by a public facility corporation.
Chair recognizes Mr. Flynn to explain the bill.
Thank you, Mr. Speaker and members. This is a public finance corporation, enables cities and counties and housing authority to finance public buildings.
Mr. Speaker.
Passage.
Mr. Canales, for what purpose?
Gentleman yield for a couple
Gentleman
questions.
yield for questions.
Yes.
Gentleman yields.
So just, and correct me if I'm wrong, this is going to allow them to get into the housing business?
No, it's a opportunity for them to use it for financing public and private corporations.
So,
Yeah.
but for housing?
It's not just for housing, no.
But would housing be
Public
included?
facilities with revenue.
Would housing be included?
They could use that as something.
So a municipality would be able to get into a business wherein they...
No, it's not getting into a business.
Well, if you're financing something, Representative, you're in the business. So my question
They're not
is...
a taxing authority, Representative.
So then explain to me when you say they're going to get into the financing of housing.
It's a opportunity for them to use public and private facilities to create and issue revenue bonds for facilities.
For housing facilities, potentially?
It doesn't designate housing facilities.
But they could be included?
It's mostly for, I don't know if it has housing or not. It's mostly for buildings, businesses.
So the municipality...
You might want to check into housing, but I don't think that's not something that's
respectfully, Representative, that's what I'm trying to do. And there's a lot of bills that are moving quickly, and that's what I'm trying to do, is check into it before it passes. Is this bill going to allow municipalities to get into financing infrastructure for private entities?
It will confirm that eligible government sponsored under the statute has the ability to create a PFC to finance, own, and operate a multifamily residential development and benefit from tax exemption under current law, but only if the development meets the occupancy reservation requirements in the statute or accomplishes a government purpose. So
ostensibly, taxpayer dollars are going to be able to bankroll private entities.
This is for lawyers that think the development of a multifamily residential rental development is already authorized under the current statute.
Thank you.
Yes, sir.
Mr. Speaker.
Mr. Anchia, for what purpose?
Will the gentleman yield for questions?
Gentleman yes, sir. Gentleman yields.
Dan, you and I have served on the Financial Institutions Committee back when that was a thing, and you're a former banker. I'm a former corporate finance lawyer, or still some. But I just wanted to correct something that I think was coming from the back mic earlier and help you out, help the members out in understanding what the bill tries to do. If you are in a debt position, you are not in the business, correct? If you are financing debt and providing debt, you are not in the business. If you are providing equity, you are in the business.
Yes, sir.
Right? And you take a piece of an LP or a GP, a general partnership. then you are in the business itself. So, but what you, I think, are talking about are debt instruments, right?
Bonds,
Whether it's
yes.
bonded indebtedness,
Right.
which is a debt instrument which is amortized over a long period of time, and therefore the entity furnishing the debt is not in the business. Is that correct?
That's correct.
Thank you.
Yes, sir. Move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, question occurs on final passage. It's a record vote. The clerk will please ring the bell. There being 101 ayes and 44 nays, the bill is finally passed. Chair lays out on third reading and final passage Senate Bill 1940. The clerk will please read the bill.
SB 1940 by Hancock, relating to the administration of a temporary health insurance risk pool.
Chair recognizes Dr. Oliverson.
Thank you, Mr. Speaker. Members, this bill reestablishes the high-risk pool for health insurance in the event that we should need it in the interim. Move passage.
Is there anyone here wishing to speak on, for, or against the bill? Seeing no one, all the record vote for final passage. The clerk will please ring the bell. There being 146 ayes and 1 no, the bill is finally passed. Chair lays out on third reading Senate Bill 2212. The clerk will please read the bill.
SB 2212 by Taylor, relating to maintenance and operations of certain projects by certain drainage districts.
Chair recognizes Mr. Paul to explain the bill.
Coastal barrier projects.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will please ring the bell. There being 147 ayes and 0 noes, the bill is finally passed. Chair recognizes Representative Hernandez for a motion.
Thank you, Mr. Speaker. Members, I move to suspend House Rule 8, Section 5D, to designate as joint sponsors and co-sponsors Senate Bill 2551, all joint authors and co-authors for House Bill 1521, and to add Mr. Goldman as a co-sponsor.
Members, you've heard the motion. Is there any objection? Chair hears none. So ordered. Chair lays out on third reading Senate Bill 2551. The clerk will please read the bill.
SB 2551 by Hinojosa, relating to the liability of certain political subdivisions for certain workers' compensation claims and actions.
Chair recognizes Mr. Burrows to explain the bill.
Thank you, Mr. Speaker. Members, this bill will do a lot to help our sick and dying firefighters and their families. Very proud of the work a lot of people did on this. And with that, I'll move passage.
Is there anyone else here wishing to speak on, for, or against the bill? Seeing no one, it's a record vote for final passage. The clerk will please ring the bell. There being 142 ayes and 2 nays, the bill is finally passed. Chair lays out on third reading and final passage Senate Bill 815. The clerk will please read the bill.
SB 815 by Rodriguez, relating to the creation and preservation of certain records of criminal proceedings.
Chair recognizes Mr. Moody to explain the bill.
Hey, Mr. Speaker, members, I think Mr. Speaker, Mr. King may have some questions.
Mr. King, for what purpose?
Will the gentleman yield for a few questions?
Gentleman yield for questions.
Yes.
Gentleman yields.
Thank you, Mr. Moody. And I think we started off with a really good bill yesterday, and I thank you for bringing it. was an amendment that went on, and I wanted to ask you a couple of questions about it, if you could kind of help clarify.
Yes, sir.
The bill, or the amendment that went on, prohibits a law enforcement officer from making a warrantless arrest on a Class C misdemeanor, which has no jail time attached to punishment, unless the officer with the arrest filed a report and the magistrate found in that report that there was clear and present danger articulated to the public justifying the detention of that person. Did I frame that correct?
So not quite. Nothing in that amendment strips an officer of discretion in the field. They can make those arrests, and if they so choose to do that, they are arresting and bringing an individual down to the magistrate, and the conduct we are trying to curb is doing this for no good reason whatsoever. And so the sanction at the magistrate level under the amendment is, if there's not a clear and present danger, then and you arrested this person, you don't have any articulable facts to that, then the case is dismissed. And so no discretion at the roadside is cut off whatsoever. This is a transparency piece, so that if we are, and we heard about this when Mr. White's bill was up, we're not talking about a vast majority of cases. We are talking about a limited number of cases, but that is a limited number of cases in which someone has been deprived of their liberty. And so the question at the magistrate level there is to articulate those facts as to why someone was arrested for what is otherwise a fine-only offense.
Okay. So criminal trespass comes to mind. Every day, probably hundreds of times a day in Texas, a law enforcement officer gets dispatched to a criminal trespass. Somebody's congregating where they shouldn't be congregating. Maybe it's a disruption of the peace. They're being asked to leave and they refuse to leave. There's not a danger to anybody. It may be just a big nuisance, a disruption, a problem, such as maybe we even saw in Mr. Cook's committee last session when someone was asked to leave and didn't leave. Or sometimes there's other congregations that occur. Would a criminal trespass rise to the level of clear and present danger where someone could be arrested if they refused to leave when they were just given a ticket?
Sure. So if we're talking about someone who has been asked by someone who has a superior right to that place, you're no longer welcome here, you have to leave, and they refuse to do that, that's now an arrestable offense and no longer a fine-only offense. So we're not going to get to that.
Fine-only at that
point. If they refuse to depart once given notice pursuant to the statute, then we are up into Class B world at that point. And then depending on the type of property we're on, you could be a Class A or otherwise.
Yeah, I realize that a habitation but I'm thinking...
No, it doesn't have to just be habitation.
Right, but I'm even thinking of someone...
It could be a convenience store.
Kids on a parking lot.
If the convenience store owner or the person that has the superior right says that you must depart, you're no longer welcome here, and we've given you that notice, and that notice can be given in writing or verbally under the statute. If they refuse at that point, that secondary refusal...
I may be wrong, but
is now an arrestable offense.
To get it above Class C, doesn't there have to be a posting of a sign with the correct language, things like that?
No, that's not the current state of law.
So another thing, and whether it's right or wrong, but it occurs in your neighborhood or my neighborhood, somebody calls in and they say, hey, there's a drug house operating next door. And, it takes a long time to infiltrate those, and a lot of times what law enforcement will do is just frankly start parking near that drug house and watching people come and go. And if they see someone make a traffic violation, they stop them, and they use that to build probable cause to find out what's going on in the drug house. I mean, if they pulled someone over and felt like that they were engaging in narcotics and wanted to try to temporarily bring them in on a traffic citation or something like that, would that rise to the level of clear and present danger?
I think they could. Nothing's going to preclude them from doing that under this amendment.
What about a bar fight? Let's say that you get a call to a bar fight or a fight in wherever it occurs at. Police officer pull up there, the fight's over, they're in the parking lot. A ticket's not going to do anything. If you just drive away, they're going to start a fight again. Maybe it's little gangsters or whatever. There's a need to take to jail, but you can't articulate. How do you articulate that it's a clear and present danger? And I guess that's really where I'm all going to this. How are you defining in that bill? What do you believe clear and present danger means?
Our statutes have used that terminology from our protective order statutes to others. I don't think it is a very high bar that we have to get over. So it's defined in our statutes other places. I assume that it would be utilized in the same way, same form or fashion here. The other thing in that particular hypothetical, someone who's intoxicated has been in an altercation clearly is a danger to themselves or someone else. And so I think those facts, again, that's up to the magistrate, but I think those facts on their face would get you past this.
Last one, and this is the really big one, and we've talked about it. So a police officer pulls someone over in a traffic violation. They want them to sign the ticket as a promise to appear. That's like a cash bond in place. And so they ask them to sign the promise to appear, and they refuse to sign it. Or they're willing to sign it, but the officer can just tell this person, they don't have an ID, they're lying to me about who they are, they don't have insurance, they don't have a driver's license. They say their name is Sam Smith, and you can just tell they're lying about it. How do you deal with not being able to, if you let them go, you're never going to see them again, or if they just refuse to sign the ticket for the promise to appear?
So you raised two different fact sets there. One of those is failure to ID, so we can arrest you for that. So that's to the wayside.
Well, not if they're giving you a name, but
you just said they gave you a clearly false. You said they gave you a clearly false name. So that's failure to ID.
You're talking to them, you just tell it's a bad name.
Sorry. The other situation I think is something. So here's the way I think that would happen in the real world today and under this amendment. Although I did draft an amendment to the bill to help address this.
And
hopefully,
could you tell us about that amendment?
We can bring it up, but I do want to say that if you refuse to sign, it does not relieve you of the requirement to appear in court. So you're still required to appear, and if you fail to do so, a capias will be issued for your arrest. And so someone can thumb their nose at the officer there at the scene, but an arrest warrant will be issued quickly. But rather than kind of get into the weeds on that, I think it's better if we could talk about the amendment.
Yeah, why don't you do that amendment?
Thank you.
Thank you.
Following amendment, the clerk will please read the amendment.
Amendment by Moody.
Chair recognizes Mr. Moody to explain the amendment.
Thank you, Mr. Speaker, members. And so this amendment addresses the last portion of the discussion that Mr. King and I were having regarding someone's refusal to sign their promise to pay or promise to appear in court. While I think that that individual would still get a capias issued for them in short order, instead of arguing about how that may or may not happen in the real world, we're just going to build it right into this bill, which says if the person refuses to sign the citation, promising to pay the fine or appear in court, and they cite that to the magistrate, then we're all clear. There's no problem with the arrest that was made. So now we have two instances in which the officer can justify the arrest in a fine-only offense rather than just the one, which is the amendment as it was.
Mr. Speaker.
Mr. Lang, for what purpose?
Will the gentleman answer a question?
This gentleman yield for questions.
Yes, sir.
Gentleman yields.
When you attach this to the bill, the officer still has the discretion for the stop, correct? If there's a Class C, there's a traffic offense committed, the officer stops the vehicle, correct?
Yes, sir.
Okay. So that officer at this time can now arrest that subject for a Class C offense.
Are you talking about under current law or
Yes.
under the bill as amended?
Current.
Yes.
Okay. Under this, under your amendment, and this part of your
The
amendment,
current amendment that's before the body or the amendment that we adopted yesterday?
as a whole, your whole amendment now, how it refers to your whole amendment.
Well, this
if
hasn't
gets
been
on.
adopted by the body yet, but I'll answer questions as if it had.
Okay. This just adds the second part for the officer. So if the officer arrests somebody, they take the person to the magistrate. The magistrate says it's not a clear and present danger. The person is not a clear and present danger to himself or somebody else. That person is let go.
Well, I actually don't think that's what the magistrate would be doing in that situation. I think that the officer would be required to submit to the magistrate why they made an arrest and why this person was a clear and present danger, and that's why they deviated from the normal practice, the overwhelmingly normal practice of citing and releasing the individual. And so I think the requirement is to create a record of why the officer at that point chose to utilize discretion in that case. And so, that along with this would certainly still allow someone to be arrested, but in far fewer circumstances, and I think would advance good public policy.
Public policy the state creates for each department.
We get to decide the constructs by which these interactions occur, and right now there's not a lot on fine-only offenses that allows us to know why that discretion was utilized. And so this amendment is not Mr. White's bill, but it does allow us to start to gather information as to why someone would deviate from the overwhelming majority of cases and arrest in a fine-only situation. And if that is not a good reason, or the person refused, then, absent those, then the sanction is you don't get to go forward with that case. Because the public policy is if we have fine-only offenses and there's no danger to society, then why are we bringing this person before the magistrate? No, move adoption.
Mr. Moody sends up an amendment. The amendment is acceptable to the author. Is there any objection? Chair hears none. The Moody amendment is adopted. Chair recognizes Representative Collier for a motion.
Thank you, Mr. Speaker. I move to suspend House Rule 8, Section 5D for SB 815 to designate the following members as joint sponsors: Thompson of Harris, Collier, and White.
Members, you've heard the motion. Is there any objection? Chair hears none, so ordered. Is there anyone here wishing to speak on, for, or against the bill? Chair recognizes Mr. King in opposition.
Thank you, Mr. Speaker. Members, if I can get everybody's attention, because Mr. Moody's working on a problem here that is an issue, a real issue, and but what he's trying to address here is fixing it in the wrong way, and it creates a lot of problems in the law enforcement world. First off, he is absolutely right, as Mr. White was absolutely right, that we have way too many people sitting in jails today, thousands sitting in jails in Texas today, on Class C misdemeanors. And see, Class C misdemeanors are generally punishable by fine only. The problem is, and there's two ways people get arrested for Class C. The vast majority of them are people who got traffic tickets or some ticket for shoplifting, some minor item or something like that, and they didn't pay it, and so a judge issued a warrant for their arrest. A much smaller number of people that go to jail for warrantless arrests. The officer stops them on a traffic violation, believes they need to be arrested, or it's a drug paraphernalia, or it's fighting in a bar, or disturbing the peace, or criminal trespass, or something like that, and the officer takes them to jail because you can't just give them a ticket because the crime's going to continue. If you really want to fix the Class C misdemeanor arrest problem, the real way to do it is to deal with, and I hope we will next session, the cost of traffic citations. That's how probably 90% of the people that go to jail on Class C's, that's what they go to jail for, not paying traffic tickets. And you get pulled over, and it's a red light and an inspection sticker, and now you got $425 worth of tickets, and you make $800 a week, maybe, five, whatever you make, and you can't pay it, so it goes delinquent. They issue a warrant. Now you got warrant fees. Now it's a $900 citation. You get pulled over. The officer takes you to jail because there's warrants for your arrest. Now you're going to cost $250 to get your car out of hock because it was towed in. That's why people go to jail for Class C misdemeanors. Warrantless arrests are very rare, and most departments strongly discourage them. Now, so that's the way you really fix with it, is make tickets cheaper, and that's what we really need to do. But that's not what this bill is about. What Mr. Moody is dealing with is when an officer pulls over somebody, and maybe they know they're not telling them who they are. They're refusing to sign a traffic ticket or something of that nature. Or maybe they pull up to a bar fight, and the fight's over, and they need to take them to jail. It's a Class C misdemeanor because fights are going to continue if they don't. Or it's criminal trespass, or it's congregating, or it's other disturbing the peace. There's just times people just need to go to jail. You cannot just leave them there, even though it's a Class C misdemeanor arrest. There are just times people need to go to jail.
Mr. Wood, for what purpose?
I'll wait.
Okay, just one
minute.
minute.
Not at this time, Mr. Wood.
The concern about Mr. Moody's amendment that he put on yesterday and is touching up a little bit today, it says that when an officer needs to arrest somebody on a Class C misdemeanor, that they have to put in their report that there was a clear and present danger if they do not make that arrest. And then it says if that report doesn't articulate that, when they get to jail, the judge, the magistrate who sees them, has to dismiss the charge. It is one thing to do what Mr. Moody is really wanting to do, I believe, is reduce warrantless arrests. It's another thing to say that because an officer didn't articulate something correctly in a report, that the person is found not guilty of something that they were very guilty of. They did get in a fight. They did expose themselves in public. They did commit a minor assault. that didn't have a lot of bodily injury. They did criminally trespass, but because there wasn't a clear and present danger, they needed to go to jail. They needed to get out of there, but because there wasn't a clear and present danger, which is a high standard, the judge is going to have to say, you're dismissed, turn away and walk out. And that's the concern, and that's why this amendment, which is well intended, goes way too far, and it's going to dramatically hamper, it's going to dramatically change the way law enforcement enforces the laws today.
Mr. Speaker.
Mr. Wu, for what purpose?
Would the gentleman yield for
Will
questions?
the gentleman yield for questions?
Absolutely.
The gentleman will yield.
Representative King, I appreciate your attention to this subject, but the scenarios you just listed were individually addressed in your back and forth with Representative Moody. Did you not hear his answers to your questions?
I don't think the situations we gave attention to, such as the bar fight's already over. How is there a clear and present danger? The gang
Moody,
members are still congregating, but you can't produce a clear and present danger. The person shoplifted, you know they're going to do it again, but it's not a clear and present danger. That's the phraseology that I think is going to create a lot of problems.
So, for example, you mentioned criminal trespass, and criminal trespass is already a misdemeanor B. It's already a must-arrest offense.
No, it can be a Class C.
No, we've tried to pass that every session. That bill never gets through.
But you have city ordinances that are Class Cs, and this would apply to those
That's
as well
correct,
for criminal
but
trespass. Drug
criminal
paraphernalia,
trespass
a lot
off
of
another's
other things.
property is a Class B misdemeanor. It is a must-arrest offense already.
Unless it's a municipal offense, which they do have those, and those are Class C.
If you have someone fighting in a parking lot, that could be an assault, which is a Class A must-arrest offense. Did you know that?
Assault for slapping someone or something like that is Class C.
A slap, if it causes pain, is a Class A assault bodily injury. Just as it is a domestic violence case if you slap a spouse or a loved one. Okay? Those are Class A must-arrest offenses.
Congregating,
Again,
all those things that happen in parking lots that officers have to deal with. Minor shoplifting that's going to go on and on and on. Cursing in public, standing out in public, screaming and yelling, disturbing the peace. You can't just walk away from it, but there's no clear and present danger to anybody, but you got to get the person out of there. Yeah. Same thing happened to Mr. Cook's committee last time.
Do you think that there should be some standard for when an officer arrests someone?
Absolutely. That's why we need a statute that requires a written standard, a written policy in every police department that's published regarding warrantless arrest that people can be held to. We need a TCOL standard, model policy for the state on warrantless arrest, and we need to reduce the cost of traffic tickets so people aren't going to jail constantly on these Class C misdemeanors.
Do you believe that someone who doesn't look right to the officer is a proper standard?
Oh, of course not.
Yeah.
And a good policy prohibits those type of arrests.
And right now, there is no policy that stops someone from arresting someone on a Class C because they don't like the way they look. That is the current law, correct?
Well, it would be against the law today to arrest someone because there is no offense if I don't like the way you look.
Is that
I know
the
where
current
you're
law?
going with it, but Mr. Moody's amendment does not stop that. That is police misconduct.
In fact, Mr. Moody doesn't really change what we do right now. It just says that if a person was unlawfully arrested for a fine-only offense, by the time they're arrested, hauled downtown, inventoried, put in jail, and then later on, many times in smaller counties, let me finish my question. And many times in smaller counties, it could be 12, 24 hours or more before they even see a magistrate. Someone could spend a day in jail for a fine-only offense.
And if it did not involve a clear and present danger, which a lot of things that people need to be arrested for don't, then the judge would look at it and say, even though you're guilty, I'm dismissing the case and releasing you from jail, even though you're guilty.
And even
that's
though
a
that
whole
person,
different deal.
for a traffic violation, has spent a day in jail, you would rather them stay in jail longer.
No. On any traffic offense, first off, you can't arrest somebody for speeding. That's in the state code.
There are many traffic offenses
but
other
other
side
traffic
of speeding.
offenses you can, but if, as a general rule, if people sign a promise to appear they just get the traffic citation and leave. But you know, sometimes people don't do that. Or sometimes you know they're lying to you about who they are. They're telling you their name, you know it's not them, they don't have a driver's license, they don't have insurance, the car doesn't register to them.
Again,
does signing a ticket really
Mr. Kraus
mean
raises a point of order. The gentleman's time has expired. The point of order is well taken and sustained.
Members, I would ask you to vote against this bill because of the third reading amendment, or second reading amendment was put on.
Does any other member wish to speak on for or against Senate Bill 815? If not, the chair recognizes Representative Moody to close.
Thank you. I do want to address a couple of things. We talked about very specific instances here on the microphone. So trespass, criminal trespass is a Class B arrestable misdemeanor. You can get a warrant for that. Failure to ID is a Class B misdemeanor if they give false information. In assault, no matter what level of pain, if physical pain is felt, that is a Class A misdemeanor. Also, the decision the magistrate is making under the amendment isn't whether the reason that the officer placed was acceptable. It is saying if they refuse to place it in the report, case dismissed. That is the way the amendment reads. It needs to be articulated in the report. The magistrate isn't there to check whether that raises to the right threshold. It has to be in there. That's the way the amendment reads. Members, I have fought for law enforcement and law enforcement officers for my entire career here. I have a stack of awards across multiple sessions from law enforcement groups. I am for the police, but I am not for unlimited police power. The overwhelming majority of police officers are good people who want to do good things for their community. But good people are still people. People sometimes make mistakes. People sometimes let their emotions get the better of them. People sometimes lose sight of the fact that how we get there is as important as the destination. That's why we have rules to constrain some behavior and incentivize other behavior. A smartly designed system makes the people in it better. And all of us, right here, right now, in this chamber, are deciding what our system should be. The system we've had in place is why Chairman Coleman is hearing from the AG and DPS this morning about new revelations in the Sandra Bland case. Whatever we think of how everyone involved in that case behaved, the fact is that Sandra Bland would be alive today if the system hadn't allowed her ticket to become an arrest. We have a chance to make an incremental change to that system today. SB 815's amendment doesn't prevent Class C arrests. I wish it did, but we can't get there with this bill. This doesn't go nearly as far as Mr. White's bill, which passed out of here 126-20. What it does do is say that an officer who arrests someone for something like failure to signal or not wearing a seatbelt has to explain to the judge why it was an arrest and not a ticket. Otherwise, the penalty is that ticket gets thrown out. The person still got arrested and brought to the judge, but at least now we have an incentive for the behavior that we expect. A simple explanation and justification isn't too much to ask for what should be a rare event. And no one should be against that kind of transparency and accountability. I ask you to join me in taking a small step towards a fairer, smarter system that's going to keep good officers doing good work. And I move passage.
Question occurs on final passage of Senate Bill 815. It's a record vote. The clerk will ring the bell. Show Representative King of Parker voting no. Have all voted? Have all voted? It means 70 ayes and 74 nays. Senate Bill 815 fails to pass. Members, verification has been requested. Verification will be granted. Please take your seats. Members, please take your seats. The clerk will proceed to call the names of those voting nay.
Allison. Allison.
Yes.
Anderson.
Yes.
Ashby.
Yes.
Bella Montgomery. Bella Kaufman.
Yes.
Biederman. Bohack. Bohack.
Is Mr. Bohack on the floor of the House? Strike his name temporarily.
Bonin of Galveston.
Yes.
Buckley.
Yes.
Burns.
Yes.
Burrows.
Yes.
Button.
Yes.
Capriglione. Clardy. Craddock. Cyrier.
Yes.
Darby.
Yes.
Dean.
Victoria.
Dean.
Yes.
Fiero. Flynn.
Yes.
Frullo. Frullo?
Yes.
Yep. Guerin.
Is Mr. Guerin on the floor of the House? Strike his name temporarily.
Guillen. Guillen.
Is Mr. Guillen on the floor of the House? Strike his name temporarily.
Harless. Harris. Hefner.
Yes.
Holland. Huberty. Hunter. Cassell. King of Hempel. King of Parker. Click. Kemple. Kemple.
Mr. Kemple.
Is Mr. Kemple on the floor of the House?
Okay. Lambert. Lambert.
Is Mr. Lambert on the floor of the House? Strike his name temporarily.
Landgraf. Lang. Larson. Lamont. Lozano. Metcalf. Middleton. Miller. Morrison. Munoz. Murphy. Murr. Noble. Oliverson. Patty. Patty.
Is Mr. Patty on the floor of the House? Strike his name temporarily.
Parker. Patterson. Paul. Phelan.
Is Mr. Phelan on the floor of the House? Strike his name temporarily.
Price. Rainey. Sanford. Schaefer. Shaheen. Sheffield. Shine. Smith. Smithy. Springer. Stevenson. Stuckey. Swanson. Thompson of Brazoria. Tinderholt. Van Dever, Wilson, Ray, Zedler, Zerwas. That's it.
The clerk will proceed to call the names of the vote of those voting aye.
Allen, Anchia, Bales, Beckley, Bernal, Blanco, Bowers, Busey, Kane, Kalami, Canales, Cole, Coleman, Collier, Cortez, Davis of Dallas, DeSoto, Dominguez, Dutton, Farrar, Gervin Hawkins, Gonzalez of Dallas, Gonzalez of El Paso, Goodwin, Guerra, Gutierrez, Hernandez, Herrero, Hinojosa, Howard, Israel, Jarvis Johnson of Harris, Julie Johnson of Dallas, King of Uvalde, Kraus, Leach,
Mr. Leach on the floor of the House, strike his name temporarily.
Longoria, Lopez, Lucio,
Is Mr. Lucio on the floor of the House? Strike his name temporarily.
Martinez, Fisher, Meyer, Meza, Minhades, Moody, Morales, Nevadas, Ortega, Pacheco, Perez, Ramos, Raymond, Reynolds, Rodriguez, Romero, Rose, Rosenthal, Sherman, Stickland, Tallarico, Theory, Thompson of Harris, Toth, Turner of Tarrant, Turner of Dallas, Vo, Wally. White. Wu. Zwiener.
Is Mr. Bohack on the floor of the House? Were you present and voting nay? Verify Mr. Bohack. Is Mr. Guerin on the floor of the House? Were you present and voting nay? Verify Mr. Guerin's vote. Is Mr. Guillen on the floor of the House? Strike his name. Is Mr. Lambert on the floor of the House? Were you present and voting nay? Verify Mr. Lambert. Is Mr. Patty on the floor of the House? Were you present and voting nay? Verify Mr. Patty. Is Mr. Phelan on the floor of the House? Strike his name. Is Mr. Leach on the floor of the House? Strike his name. Is Mr. Lucio on the floor of the House? Strike his name. Members, the following members' machines malfunction. Representative Niave was shown voting present. Her machine malfunction. Please show her voting aye. Representative Fierro, his machine malfunction. He was shown voting no. Please show him voting aye. Mr. Munoz, his machine malfunction. He was shown voting no. Please show him voting aye. Mr. Frank, his machine malfunction. He was shown being absent. His vote was nay. Members, we'll have order in the chamber. Members, the vote shows 71 ayes and 71 nays. The bill fails to pass. Please excuse Representative Lucio because of important business on a motion of Representative Hernandez. Is there any objection? Chair has none.